Hey there and welcome. We often think that once a bill gets passed by a legislature, that's it, job done. But there's this one final, absolutely critical step that's recently turned into a major political battleground here in India, and that is the assent of the president or the governor. This one single step can either make a bill the law of the land, or, well, it can leave it hanging in limbo forever. Today, we're going to unpack this constitutional gray area.
All right, so here's how we're going to break this all down. First, we'll look at the recent constitutional showdowns that have really brought this whole issue to a boil. Then, we'll get into the weeds of what the power of assent actually is. From there, we'll trace the journey from a simple bill to an official act. Then we'll tackle the real heart of the problem, this dilemma of indefinite delay, before looking at the Supreme Court's decisive role, and finally, we'll chart out the path to some much-needed clarity.
So let's set the stage. What should be a pretty routine procedural step has, well, it's blown up into a massive political flashpoint. We're seeing more and more friction between elected state governments and governors who are appointed by the center. And this bill assent process is getting caught right in the middle, turning into a tool for political fights and creating some serious roadblocks for governance.
And that really begs the question, right? Can a governor, who is an unelected head of state, actually kill a law that's been passed by a democratically elected assembly just by doing nothing? Can they just let a bill, which represents the will of the people, sit on a desk and collect dust until it effectively vanishes into a constitutional black hole? This is the very question that has now climbed all the way up to the Supreme Court.
And you know what? The judiciary has weighed in, and they are not mincing words. This statement from the Supreme Court, it isn't just a friendly suggestion, it's a hard-hitting constitutional interpretation. What the court is saying here is that doing nothing, just sitting on a bill for ages, isn't a valid option. In fact, it's an unconstitutional act that actively undermines the entire democratic process.
And look, this isn't just some abstract theory we're talking about. This is happening right now. The big showdown in Tamil Nadu, where Governor R.N. Ravi's long delays on a whole bunch of bills sparked a massive legal battle, is the perfect example. This real-world conflict showed everyone just how a tiny loophole can cause complete legislative paralysis, stalling important policies and creating a full-blown constitutional crisis. It's this case that has forced the entire country to look this problem right in the eye.
Okay, let's switch gears a bit. To really get a grip on the conflict, we first need to understand the power that's at the center of it all. So what exactly is this power of assent? And why did our Constitution's framers even put it in there? Is it just a leftover from the colonial era, or does it actually serve a vital purpose today?
So in simple terms, bill assent is that final green light, that formal seal of approval a bill needs from the head of state, that's the president for central laws, or the governor for state laws, to officially become the law of the land. It's not just a ceremonial signature. It's the mandatory last step that transforms a proposal into an enforceable act.
So why even have this step? What's the point? Well, it actually serves a bunch of vital functions. It acts as a critical check and balance, kind of like a final safety net to stop hasty or unconstitutional laws from getting through. It helps make sure state laws don't clash with national laws. It can even be used to improve a bill by sending it back for another look. And, most importantly, it's a constitutional guardrail to protect our fundamental rights.
Let's make this practical. Imagine a state passes a bill with some massive, unforeseen financial costs. Let's say a new scheme that could blow up the state budget by more than 15%. In this case, the governor's power to return that bill for another look isn't about blocking it. It's about forcing a responsible and necessary financial review. It shows how the power is supposed to improve governance, not obstruct it.
Okay, so we've covered the what and the why. Now let's dive into the how. How does a bill actually make this journey into law? Who are the key players in this drama? And what specific powers do they have at this make or break stage?
You've basically got four main actors on this stage. First up, the legislature. That's Parliament or the state assemblies, the elected folks who write and pass the bill. Second, you have the executive head, the president or the governor, who has to give that final nod. Third, there's the Council of Ministers, who are there to advise the executive. And finally, kind of watching over everyone, you have the judiciary, who are the ultimate umpires of the Constitution.
Now, this whole process runs on two parallel tracks. At the national level, a bill passes through both the Lok Sabha and Rajya Sabha and then lands on the president's desk. Simple enough. At the state level, a bill passed by the legislature goes to the governor. But here's where it gets interesting. Sometimes the bill's journey doesn't end there. The governor can send it all the way up to the president, which adds a really crucial federal layer to the whole system.
And just to make things a little more complex,
In about 6 states, think Uttar Pradesh or Maharashtra, they have 2 legislative houses. So a bill there has to clear both the Assembly and the Council before it even gets a chance to reach the governor. It's a process designed for more debate, sure, but it also means an even longer journey for a bill to become law.
So the bill has finally reached the governor. Now what? Well, under Article 200 of the Constitution, they basically have 4 cards to play. Option 1, give assent, and boom, the bill becomes law. Option 2, withhold assent, which is basically a full-stop veto. Option 3, return the bill for reconsideration. And Option 4, reserve the bill for the president to look at.
The president has a similar playbook under Article 111. They can give assent, withhold it, or send a non-money bill back for another look. But here's the massive difference. The president can't reserve a bill for someone else. That power, to send a state bill up to the president, is unique to the governor, and it's a really critical feature of our federal system.
And this right here is where we get to the heart of the whole mess. All those options, assent, withhold, return, reserve, they all sound pretty clear, right? But what happens if a choice is just never made? This is where we find a huge loophole in the Constitution, and it all comes down to timelines, or rather, the lack of them.
Get this. This is the phrase that's causing all the trouble. As soon as possible. That's what the Constitution says about how quickly a bill should be dealt with. It doesn't say within 30 days, it doesn't say within 6 weeks, just as soon as possible. A phrase so vague, so subjective, that it's become the root of this entire problem.
And this ambiguity allows for a sneaky tactic called the pocket veto. It's exactly what it sounds like. It's a veto not by saying no, but by saying nothing at all. The head of state basically just puts the bill in their pocket and forgets about it. They don't say yes, they don't say no, they don't send it back, they just do nothing, and by doing nothing, they effectively kill the bill.
The real-world impact of this, it's just staggering. We're not talking about a few weeks' delay here. In some states, absolutely crucial laws, bills about education, local governance, public welfare, have been stuck in this limbo for over 20 to 24 months. That's 2 whole years of work by an elected legislature completely frozen because of one person's inaction.
So you can see how this one little phrase creates a domino effect of problems. It allows for political games where a governor might block a state government from a different party. This obviously creates huge friction between the center and the states. It leads to a complete deadlock, grinding the wheels of governance to a halt. And most fundamentally, it just tramples on the democratic will of the people.
All right, so with the politicians stuck in a deadlock, who steps in to sort things out? Well, the judiciary, of course. The Supreme Court has had to step into the ring as the constitutional referee to break this impasse and finally interpret what that vague language in the Constitution really means.
To really get a sense of the scale here, just look at this number, 10. In that landmark Tamil Nadu case, this wasn't about 1 or 2 bills. The governor had kept 10 different bills, all passed by the state legislature, just sitting on his desk for a very, very long time. This kind of systematic delay is what forced the state government to knock on the Supreme Court's door.
And the court's verdict? It was absolutely crystal clear. It declared that the governor's long period of inaction was not a legitimate use of his power. In fact, they called it unconstitutional, a move that actively sabotaged the democratic process. The court basically said, as soon as possible, cannot be twisted to mean whenever you feel like it.
And the court didn't just stop at words, it took action. To break the logjam, it used a special tool in its arsenal, a kind of constitutional superpower called Article 142. This article gives the court the extraordinary power to do whatever is necessary to ensure complete justice. And in the Tamil Nadu case, it used this power to grant deemed assent, basically overriding the governor's inaction and turning the bills into law. Now, this bold ruling made such big waves that it went all the way to the top. In a huge development, President Draupadi Murmu, seeing that this was a nationwide issue, decided to formally ask the Supreme Court for its opinion on the matter. This took the issue from being about a single case to a fundamental question of constitutional law for the whole country.
And the president did this using something called Article 143. Think of it as a constitutional hotline to the Supreme Court. It gives the president the power to ask the court for its take on any major question of law or public importance. The court's advice isn't technically binding, but it carries enormous weight and is meant to provide clear constitutional guidance.
So what's the core question the court is trying to answer now? It really boils down to this. Does the option to withhold assent give a governor the power to just kill a bill by shelving it forever?
Or are they constitutionally required to pick one of the other options, give assent, return it, or reserve it for the president, and do it within a reasonable amount of time? The answer is going to redefine the limits of a governor's power.
And this table here really lays out the subtle but crucial differences. You can see that while both the president and governor have similar powers to say yes or no, that unique ability of the governor to reserve a bill for the president is a real game changer. That distinction is right at the heart of the debate about the balance of power in our country today.
So, where do we go from here? With the ball now firmly in the Supreme Court's court, the whole country is basically holding its breath. What are the potential long-term solutions that can finally bring some clarity to this constitutional gray area?
Broadly speaking, it looks like there are three main paths forward. The most direct route is a constitutional amendment to just fix the wording. The second is to strengthen our unwritten constitutional rules, our conventions. And the third, which is already happening, is to get a clear, binding ruling from the Supreme Court.
The most surefire solution would be to just amend the Constitution itself. An amendment could simply go in and replace that vague phrase "as soon as possible" with a hard, fixed timeline. That would get rid of all the ambiguity, close the loophole for the pocket veto, and make the responsibilities of the head of state absolutely clear.
So what kind of timeline are we talking about? Well, many experts and legal scholars are suggesting something reasonable, probably in the ballpark of 30 to 60 days. That's enough time for a proper review, but not so long that it allows for politically motivated foot-dragging. A clear deadline would bring some much-needed accountability into the process.
But, laws aren't everything. A healthy democracy also runs on unwritten rules, on conventions. So another path is to build a stronger political culture where these discretionary powers are used the way they were meant to be, rarely and for genuine constitutional reasons, not as a weapon to fight political battles. This, of course, requires maturity from all sides. And that brings us back to the judiciary. Let's be real. The most immediate thing everyone's waiting for is the Supreme Court's opinion on that presidential reference. A clear, strong judgment that lays down the rules of the game, the boundaries, the timelines, the responsibilities, could provide the definitive legal framework we need, and it would have a massive impact on the future of center-state relations.
And that leaves us with one final big question to chew on. This whole assent process was designed to be a thoughtful check on power, not a political veto. As we wait for the Supreme Court's wisdom, we really have to ask ourselves, is a strict legal timeline the only way to make sure the will of the people is respected? Or can our democracy find a way to build stronger conventions based on mutual respect and constitutional good faith? The answer to that is going to say a lot about the strength of our democracy for years to come.